Welcome back to the Constitutional Clarion. This video is about freedom of information and a recent federal court case that effectively puts a spoke into the shredders of the Commonwealth government. Now, freedom of information is supposed to make governments more accountable. But governments, of course, don't want to be accountable, particularly when the material is embarrassing or politically damaging. There are plenty of tricks that the government uses to avoid accountability and to thwart freedom of information. One of the biggest problems is that almost all power when it comes to freedom of information is held in the hands of the government, and the applicant is left to battle on and argue their case while wearing a blindfold and having one hand tied behind their back. It's impossible to argue that exemptions are being wrongly applied if you can't see the document in order to be able to prove that this is the case. Moreover, the cost and the risk of litigation is so great that the government knows that few, if any, people will ever take it to court to challenge its decisions. And this tends to lead to, at best, sloppy decision-making, and at worst, deliberate attempts to thwart the application of the Freedom of Information Act. And this is why it's so delightful to see that someone has challenged one of the tricks that is used to thwart accountability under FOI. And this is the case of Patrick and the Attorney General for the Commonwealth from 2024 in the Federal Court of Australia. The case was brought by Rex Patrick, the former South Australian Senator and an FOI warrior. The case was supported by the Grata Fund, which allowed for it to be run. The FOI request in this case concerned a document that goes back to the Morrison government's Sports Rorts affair. Now, you might remember the controversy about the colour-coded spreadsheets for sports funding, which highlighted the electorates in which funding was to be granted, and the report of the Auditor General, which was highly critical of the way the scheme was managed and the decision-making process for the distribution of the funding. In the midst of that controversy, the then Attorney General, Christian Porter, was asked to provide advice. Now, Porter told the media that he was waiting upon some advice from the Australian government solicitor to help inform his advice, which he'd then give to the Prime Minister. And according to the Prime Minister in a press conference, the Attorney General advised that the Auditor General's assumption arising out of his interpretation of the relevant statute was, quote, not correct, unquote. Now, I've always been intrigued by this because, as far as I can tell, the Auditor General was actually correct. And it would therefore be extremely useful, both for the Auditor General and for commentators like me, to find out why the Attorney General thought otherwise. Now, perhaps I've been wrong, and if I saw the advice, maybe it might change my mind. It might also better inform the Auditor General's approach for the future. But curiously, neither the Attorney General nor his department during parliamentary committee hearings was actually prepared to say what was not correct or to provide the legal advice so that it could be scrutinised. Apparently, the Attorney General and the Prime Minister can criticise the Auditor General for being wrong, but the nature of the error and how it could be corrected has to be kept secret from everyone, including the Auditor General. Now, this is obviously insane and clearly not a rational way to run a government, but it was just one of the many instances where an obsession with secrecy overcomes any acceptance of scrutiny and accountability. Rex Patrick sought a copy of this advice under FOI. Now, he sought it from the Attorney General's Department and the Department of Prime Minister and Cabinet, but both of them denied that they had it. The request was then later revised, so it was directed to the Attorney General's office, that is, his ministerial office. This office, on behalf of the then Attorney General, Christian Porter, acknowledged that it did hold one document falling within the request, which was the advice. But it refused access to the advice on the basis that it was a cabinet document and that it was subject to legal professional privilege, both things which fall within various exemptions in the FOI Act. Now, Patrick then applied for a review by the Australian Information Commissioner. It took more than 2 years for the Commissioner to complete the review, during which time there was a change in Attorney General from Christian Porter to Michaelia Cash, and then a change in government with the current Attorney General now being Mark Dreyfus. Now, both Cash and Dreyfus had a good look around their office and said that they did not hold the relevant document in their office. It was also asserted that it had not been transferred to the National Archives. Now, the Information Commissioner concluded that as the Attorney General does not have possession of any document falling within the request, then it was no longer an official document of the Minister to which the Act applied, and therefore she could not order its release. This is one of the many FOI tricks that are used to thwart accountability. Controversial documents may be generated in the Minister's office and retained by the Minister and not put on any official files in his or her department. When the Minister ceases to be Minister in that particular portfolio, the Minister may take some of the documents of his office with him or her and leave the rest of the documents to be shredded by the office before the handover. They are not passed on to the next Minister in the portfolio. Now, the consequence of this is that controversial documents, which may be quite important historical documents, are either destroyed or no longer an official document of a minister because the minister does not hold them. This means that they are no longer able to be accessed through FOI. Justice Charlesworth of the Federal Court, however, was having none of this. She made 2 important findings. First, that the status of the document under FOI is determined at the time that the FOI request is received by the relevant minister or department. If it's an official document of the minister, then it continues to have that status as an official document of the minister throughout any review or later appeal. Second, she held that once a claim under FOI has been made to a document, there is a legal obligation on the minister or the relevant department to ensure that the document is retained and made available for the purpose of any review or appeal until those processes are completed. There is an obligation to not deal with the document in such a way as to frustrate the provision of access under freedom of information. Her Honour considered that the Parliament could not have intended that a minister could respond to an FOI request by simply destroying the document that was described in the request and then communicating in answer to the request that there exists no official document of a minister falling within its scope. Nor could the minister, after refusing access to the document, later destroy the document to thwart merits review in accordance with the law. She described the destruction of a document that's subject to an FOI request as so antithetical to the objectives of FOI that the Act could not be interpreted to admit such an outcome. She also noted that the destruction of a document that is a Commonwealth record may constitute a criminal offence under the Archives Act. Nor did Her Honour think that an event so commonplace as a minister ceasing to hold office could result in all pending FOI applications being refused because of that change. Even if the document is not destroyed, the removal of it from the possession of the body that's subject to the FOI request could thwart the application of the FOI Act. Accordingly, the minister in possession of the document at the time the FOI request was made must maintain that position until the request is finally determined, or ensure that it's held by the minister's department, or that there is an entitlement to access to that document if it's needed. Justice Charlesworth acknowledged that the FOI applicant has a legal right to have their request determined according to the law. While the minister or department may refuse access on the ground that an exemption applies, this is not conclusive of whether the right to access exists. This is because such a claim to an exemption may be overturned upon review or appeal. That right to have the request determined gives rise to a concomitant obligation on the receiving minister or department. Her Honour said that at the very least there is an obligation not to do any act that would interfere with the right to have the request determined according to law, including any act that would frustrate the exercise of the right of review or appeal. Justice Charlesworth stated that information held by the government is a national resource to be managed for public purposes. A document held in an official capacity, she said, is not the property of the person who happens to hold that office of minister, nor of the political party to whom that person happens to belong. It's not even the property of the government of the day, for example, the Morrison government, because there's no such legal entity capable of even owning property. When a person ceases to hold the office of a minister, he or she has no personal entitlement to maintain possession of documents previously held in his or her official capacity, she said. Justice Charlesworth accepted that there would be, quote, strong political resistance to an outgoing minister transferring documents forming the subject of a pending FOI request to a new incumbent, particularly upon a change of government. She said that the court was told that it was common practice for documents not to be transferred. But she said that the FOI Act is not concerned with party political matters, but rather with enlarging the scrutiny of government activities. Now here she made her most important statement, quote, "If there be a common practice of the kind suggested to this court in submissions, it is not one that is authorised or contemplated by the FOI Act, and it should stop," she said. The balance between the maintenance of secrecy and public access is one that is struck by Parliament, she said. It's statute that determines rights under FOI, not practice or administrative convention. In other words, the practice of shredding or taking away all the documents of an outgoing minister must end. Now, the obvious way to resolve this problem, especially where a minister does not wish to transfer sensitive documents to new ministers, particularly upon a change of government, is for official documents to be transferred to the department upon the minister's departure and dealt with by that department under the Archives Act, which of course determines what needs to be kept and what can be destroyed. Any FOI application can then be dealt with by the department according to the law. It's claimed that this document is exempt because it's a cabinet record. If so, it should be held in the records of the Department of Prime Minister and Cabinet and also in the Attorney General's Department, and there should be no need for the Attorney General's office to be involved at all. If neither department actually holds this document, which frankly I really doubt, then it's an indictment upon the administration and the record keeping of the former government. Finally, Justice Charlesworth pointed out that statute, including the FOI Act, overrides administrative practice, including the Cabinet Handbook, in relation to access to the Cabinet records of a previous government. She concluded that to seek to put a document out of reach of the Information Commissioner or the court by purporting to apply the Cabinet Handbook to it is to interfere with the rights of the requesting party under the FOI Act and may constitute a breach of a legal obligation to grant access to it. All up, this is an important decision because it means that a change in minister can no longer be used as an excuse to thwart access under FOI. Of course, exemptions under the Act will still apply. If it really is a cabinet document, then it will be exempt, and Patrick will not get access to it. But the ability to prevent the Commissioner or a court from reviewing this claimed exemption by simply saying that the document is no longer held in the Minister's office will no longer work. It will also improve the records available to future historians and to the public if inconvenient ones cannot simply be taken away by ministers when they leave office or fed through the shredder, as seems to be what so often happens. It will be interesting to see whether the enthusiasm of the former Albanese opposition for scrutiny and accountability will be maintained by the now Albanese government, or whether it will appeal this decision in order to preserve the capacity to hide inconvenient documents. On that, watch this space. Thank you again for watching the Constitutional Clarion. I hope you've learnt something interesting, and I will see you next time. Goodbye.